Good afternoon, and welcome to our third installment in our roundtable series looking at Gregory versus Chohan and how to prove mental anguish damages after this plurality opinion. Today, we are so pleased to have two really insightful experts with us, Ray Perryman from here in Waco and Karen Lisko from, best I can tell, all over the country and time zones. Ray is a well-known, well-regarded expert who assists attorneys in configuring and proving up their damages model. And Karen Lisko is one of the finest jury consultants you'll ever work with, both in framing your issues, picking your jury, training witnesses, and helping you with themes. And we thought we couldn't turn to any better group than this to get to what is really at the heart of the Gregory plurality, and that is how on earth do you prove up mental anguish damages? So, Ray and Karen, thank you so much for joining Jim and me here today.
Happy to join you.
Yeah, glad you are here. So, I want to start with an admonition from your favorite law professors. We have asked these people who normally charge a great deal for this kind of expertise to hypothesize with us about some ways that you might address these challenging issues going forward. And we have assured them that this is not to be used against them later in a court of law or other setting. And so if you choose to stay on this webinar, you are agreeing to that ground rule. And if you don't want to agree, have a lovely day. Bye. So with that said, what we have decided as a group that it's going to be easiest to talk about different strategies if we do this in kind of a simulated setting, much like we would do here in practice court. And so we're going to use the Gregory versus Chohan damages facts to sort of run through some different ways this might work. And Chandler, would you mind popping up our PowerPoint? I feel like if you're on a webinar about Gregory versus Chohan, you probably know some of the basic facts, but let's just ground everybody in that again. And if you don't mind going to the next screen. So in this part of the case, we had a number of wrongful death and survival claimants. Obviously, Mr. Deal was the one killed in this truck wreck, but he left behind a wife, 3 children, and his parents, all of whom were statutory wrongful death beneficiaries. And so, Chandler, if you'll move on, the wife was the one who did a lot of the testifying here. And I think 50 pages of the trial transcript were her talking about the nature of these relationships. She lost her best friend. She was now a single parent. Obviously, the night of the wreck was very traumatic. She'd had to start taking antidepressants. They had to move as a family because they didn't have the financial support anymore. It was very disruptive to their life. And she testified to a great deal of ongoing sadness. Next slide, please. They had 3 children, and there were 2 older boys who obviously had suffered severe emotional loss, and she testified to how much their personalities had changed from happy, outgoing boys to more quiet, introverted, gone from being athletic to less active, and weight gain. And then you had Neil's daughter, who was only 7 months old at the time of his death, really never knew her father, but would look at pictures around the house and ask when her father was coming home. And so that was a whole different category of loss. And then his parents actually lived with the family, very close-knit. They spent a lot of time, the testimony was, cooking and gardening together. His mother was very emotional, crying several times a day. The father was more stoic and reserved, but the undisputed testimony was that home life had changed for the worse and that everybody was greatly saddened. And I think it was important because the opinion highlights that there was substantial evidence about the nature, duration, and severity of the loss that this family had suffered. So now, experts, if you have got to post-Gregory opinion, start putting together a mental anguish damages case, how are we going to do that? And let's start with, how do you address perhaps this generational difference? Because you've got older parents, you've got a wife, you've got children, and even significant differences in where the children were at the time of this loss. How do you hypothesize about what you might do to make this case in a way that satisfies the Gregory opinion?
Karen, do you want to go first? You want me to?
Well, I would start with the jury selection piece. So first is determining who you are persuading and who you are addressing, and of course, who you are excusing. And part of it in especially pronounced since this ruling is that it requires thinking again about who you believe is good or bad for you in a case. So obviously, both sides in this trial would be leaning in to listen to jurors talk about themselves having suffered loss, mental anguish. So let's talk about those perhaps who on the jury are in the difficult position of having been parents who lost a child. That type of juror, many people in jury selection think that's a great juror for me as plaintiff's counsel. That's not necessarily true. In fact, now this is requiring looking beyond the experience of that similar loss to an extraordinary kind of level in this specific case. And when we think about proving up damages for the plaintiff, it means you now need a juror who can say, look, I've lost a child and now I see what they're going through and it's even worse for them, because someone who has lost a child is not, again, necessarily pro-plaintiff. Think about that juror who would then say part two, which is, it's not just the experience, it's how I coped. That's the part two. That's the critical question in jury selection is, I lost a child and I had to get over it. I have to deal with it every day. Nobody's giving me money. So it requires both sides, of course, both leaning into hearing the experience to go next level up to the second piece, which is how are they coping? So someone who is coping fairly well is someone who just might be a great defense juror in this case, because we all know someone with a similar experience will be a jury expert in the case, will rely more on their own experience than they will necessarily hearing the experts describe or the parents of the decedent describe that experience.
Karen, do you think that applies as well to potential jurors who have lost a spouse? And I'm intentionally kind of separating out parents because depending on the age, it's much more common that we've lost a parent than necessarily a spouse or a child.
Right. No, I do think it applies. It applies across the board because jurors spend about a third of their time in deliberations talking about themselves. Now, that tells you that it means they are drawing upon that experience. And if it's a common experience that's not foreign, like in other, like maybe business contract cases, we've all suffered mental anguish at some level in our lives. So they're starting with that as their baseline. And it's critical to be conscientious about that, either as plaintiff or defense when you're proving up these damages. And of course, deciding who to excuse from your jury. So the parallel experience of losing a spouse, losing a child, losing a parent, of course, it all still applies. But you've got to get to that coping level to determine, did I cope poorly? Then if you're the defense, you're probably getting rid of that juror. Do you think counseling doesn't work? If you're the plaintiff, you're probably excusing that juror.
Now, Ray, you probably would want to get involved well before the jury selection process. Tell us about that from the chair of an expert witness. If we're going to try to address this generational impact, where could an expert help?
Well, obviously, this is once Karen has you a great jury, it'll be a lot easier. But yeah, it is always good to get an expert involved early on in the process, because we can help with discovery, with different ideas, with different bouncing ideas off you and that sort of thing. In essence, and I'm not an attorney and I don't understand all the legal aspects of it, but basically what this is doing is turning something that was sort of pseudo-qualitative into something that's pseudo-quantitative. I mean, there now has to be, you can't specifically calculate to the penny what someone's mental anguish is worth, but now you can't just suggest, well, maybe it's this amount. You have to have some basis for doing that. And it would vary, for generationally to some extent. There have been studies out there for years. We've done a few of them. Other people have done them in terms of the impact of mental health challenges of various types on school performance and ultimately lifetime earnings and that sort of thing that might apply for some of the younger folks. There's been some interesting stuff lately that I've become intrigued with a little bit before this case, and once I became aware of this case a little bit more. Years ago, a couple of very prominent, well, one's a psychologist and one's an economist, but they both have won Nobel Prizes in economics. To give you an idea of their stature, guys named Dan Kahneman, who's also a best-selling author, and Angus Deaton, did a study on the concept of does money buy happiness? And they did a study years ago, and it came to the conclusion up to a point, and beyond a point it doesn't. Then later, a very prominent and very competent economist from Penn did a similar study and came up with somewhat different conclusions. Then they got together with a big data set and tried to figure out what is the real answer to this. It's been published in the last year or so, and it's pretty interesting for something like this. And it has elements that could help a plaintiff or a defendant, depending. I think the plaintiff argument may be a little stronger in this case, but basically it found that yes, indeed, money can buy happiness. The primary reason being that it can solve problems, not so much what you can buy with it, but how you can solve problems. But the interesting thing about it, I think, for this application, and I've been thinking more and more about this ever since Jim and Liz asked me to do this, it basically creates a scale that people survey to get in between 1 and 100 of how happy you are. And there's about 20% of the people who are not happy, and probably not much is going to make them happy. There's that category. But the interesting thing is, as you go up the levels, there is indeed a situation where money does increase your mental satisfaction with life, and which I think from a legal perspective, that lets you translate mental anguish into money in at least a reasonable way that you can do. And let me give you a simple example here that might be instructive. Let's say on the scale of 1 to 100, you have a situation where a family is at about a 60. Okay, that's a little above average. Happily married, couple of kids, nice family, nothing exceptional, but they're pretty happy. And then this tragedy happens. This tragedy that gives rise to the lawsuit. And now, because of all the things that were mentioned in the slide that Liz put up, maybe they're down to a 30. Okay. Then you can legitimately, the defense can argue, well, if they're unhappy, no amount of money is going to make them happy, so why give them money? That's sort of the defense side of it. But the plaintiff can say, we can reasonably quantify about what it takes to get somebody from a 30 to a 60, get them back to where they were. And that particular example I picked out is about $500,000 a year is about what it takes. And so then you've got a situation where if you have a child with a large lifespan ahead of them, you're talking about a significant amount of money, even a 35, 40-year-old spouse with a significant lifetime ahead of them. And then a parent with maybe a shorter lifespan ahead of them, but nonetheless, those can get to some pretty significant numbers. And so I think, that's not perfect. It will now that we are getting court decisions like this, it will probably be refined. There are challenges, how do you determine what their level was before the accident? Because it's all survey based. You can cheat on surveys. On the other hand, there are techniques you can use to detect people cheating on surveys. So, I suspect it's going to get a little more sophisticated pretty quickly here now. But that's one that came to me that literally lets you take one level of happiness and another level of happiness and put a number on it, which is in the spirit, I think, of what this case is asking for.
Well, and Ray, one of the things that was notable in the testimony was the amount of stress and disruption that occurred in the daily routine of life. So it sounds like if you elicited that kind of testimony about, well, we didn't have his pecuniary contribution anymore, since that's one of the elements, but it was really stressful. We had to move, we had to do whatever. And that ability to reduce anxiety, knowing I could get the boys counseling. I could move us to a home that everybody picked out together and that felt more like the home we did. It sounds like not only is there this scaled response, but it would help you tell more of a story about why the money was going to buy happiness. Am I understanding that right?
Oh, absolutely. And as I'm sure Karen can verify better than I can, the storytelling aspect of this is very, very important in putting people in place. I'm sure she can speak to that significantly. But one of the interesting implications of this study and other studies that have been done over the years is when they conclude that money can indeed improve your happiness, it's not usually the fact at all that you can buy more stuff. It's the fact that you can solve problems. If my kid needs tutoring, I can get my kid tutoring. If my kid if we need better transportation, we can get better transportation. If we get stuck somewhere, we've got a way to get home. Those day-to-day stresses. If my refrigerator breaks, I don't have to sweat about if I'm going to have a refrigerator or not. Those kinds of things. It's not so much the material things that you get, it's the ability to relieve the stress associated with not having the resources to solve problems. And so I think there is, a considerable amount of merit to that. Other suggestions, things, that one of the first things that popped in my head was, the cost of counseling to get you back up to a certain level. And that can certainly be an element of this. But, by the same token, from a perspective I know some of you as attorneys are taking, if you take sort of the highest quality mental health you can get, and assume you get it twice a week for 15 years, you're talking about $200,000 or $300,000. I mean, that's not typically what the kinds of numbers that in some of these cases people want to put out there. So this gives you a better way to kind of deal with the overall broader concept of loss. And so I think it has some merit. I do.
Can I comment, Liz, on what Ray is saying? Ray, I'm picturing you on the witness stand, and pro-defense jurors would love to hear from you. I see it. But let me start with a baseline premise of what we keep finding to be true about persuasion in the courtroom. It is the job of a plaintiff's attorney to appeal to the pro-defense jurors and vice versa. And often what the fundamental mistake we see happen is a defense attorney is trying to talk to pro-defense jurors. Plaintiff's attorney is trying to appeal to pro-plaintiff jurors. And that persuasion event is lacking. In fact, when you can put your themes in your story toward the tougher audience on your jury, now you're getting to persuasion. Yeah. So, Ray, you are speaking the language of a defense-leaning juror, which is exactly what the plaintiff should want from their expert. Because you're quantifying. So this is the irony of what's going on from the Gregory v. Chohan ruling. The irony of what I think is going on is it's going to actually in some ways help plaintiffs, because the quantification is what pro-defense jurors are hungry for. Pro-defense jurors want to understand a reasonable formula, and bulk feels like the number should be $1 million for emotional distress. You have just created formula in how you've described this with Kahneman and others' research on happiness. You've also defined a ceiling. We've got a ceiling often in damages and a floor. A very well-respected researcher out of Colorado named Edith Green has written a book on damages, and I've read everything I can put my hands on from her and others on damages with juries. Her point fundamentally is the more you ask, the more you get. So if, like you just said, if you're starting with $200,000 to $300,000 and that's it, jurors aren't run away like a lot of the media points to in most cases. So they're going to start with the top ask from plaintiff, and often that goes down unless there's so much anger on the part of the jury that they're using the emotional distress category to be punitive damage-esque. And for good or for bad, it happens all the time. We get to, I've now talked to, it's just because I'm old, well over 2,000 jurors over the years. If I'm not paying attention to patterns, I'm not doing my job. And so the patterns are that if the jury feels as they're listening to an expert like you talk, like both in combination with you being so well-spoken and credible versus the defense not getting it, that they will use what the non-economic damage category asks as a punitives type of way of awarding damages. So it's a confluence of how are you doing as the plaintiff versus how is the defense doing in getting it.
So if this is a slightly plaintiff-leaning study, then what do defendants do in addition to there's not an amount of money that's going to make it okay for them, which, while true, do we then go to a different method of giving them a different formula? What does that look like?
Well, obviously, one aspect, as I said, one aspect of these studies is it kind of shows if you're at these lower levels, your plateau on happiness, money plateaus on happiness pretty early. It's not a potential thing where more and more money makes you happier and happier. So it's one of those things where, again, it's going to come down to the expert, and with coaching from someone like Karen, I'm sure, who can look at the jury and talk to the jury and explain and relate to the jury and know which jurors they're supposed to be communicating with. I mean, all those things are important when you're on the witness stand and you're in the process of doing this, and basically tell the story that in the best way you can, because there's obviously sympathy always flows in these types of cases, but that indeed they can say this much money gets you from 30 to 60, and there's a graph at 30, there's a graph at 60, and here's the difference. But as a practical matter, if you're at 30, money's probably not going to get you there. That's not the appropriate benchmark to use for this sort of thing. And so I think that's probably the defense counter. And that's one of the things that's, I think, interesting about this study. And again, more has and will develop off of this, particularly if there's more cases in more states that sort of move in this direction of requiring more quantification. But there's something there for both sides. I mean, there's something there for both sides in the study, in this particular study, which could lend itself again into stories that could be told on the witness stand.
I would also endorse the plaintiff if I were the defense, and that feels counterintuitive to a lot of defense counsel, but let me tell you, it is successful, and it's part of the story arc. Disney figured this out a long time ago, and you may have seen some of this. There are 4 elements to every good story, hands down, forever. And the 4 elements are: you start with the normal, which is pre-event, pre-accident, and establish that this is something where this was a whole family. Now, again, I'm talking as the defense. So you might think this sounds like the plaintiff's story. When the defense can capture this story, now they're onto something. The second thing is the crisis. Obviously, we know tragic accident, devastating loss. The third event is where the plaintiff and defense diverge, because both sides should be using this story arc, using different, obviously, language and storytelling, but the framework's the same. The third is the intervention. Now, if we're talking Cinderella, we're talking about the fairy godmother. If we're talking this case, the intervention for the defense is the family. Because if you can point to resilience, ability to overcome, this is all endorsement of the plaintiff, and bringing this out actually through cross-examination of the plaintiff's family, endorsing, talking about how wonderful they are instead of castigating them. Now you're setting the groundwork as the defense for this is a strong, pull themselves up by their bootstraps kind of family. And boy, did they suffer tragedy. So the endorsement is the psychological piece of it. And the defense juror who hears that says, yep. And then the final piece, fourth piece of the story arc is new normal. So obviously now the defense has a decision to make. Are they suggesting the new normal means that after the money if any money is awarded comes, that we believe that will be enough. That's obviously the difference that's got to come from the defense's strategy, which is, are we suggesting an alternative damages figure? And usually, as we know, in high devastation cases, that might be the right way to go, but they've just defined the floor where the plaintiff defined the ceiling.
Yeah,
Jim,
and
go ahead.
Just one quick aspect of that too. If in the course of the cross-examination from a defense perspective that Karen was talking about, if indeed you do develop some of those themes, that really helps the expert then on the stand tell the story of why what they're doing is credible and appropriate and that sort of thing, because you can use the words out of the mouth of the folks who are the victims to illustrate what it is you're saying and emphasize it. So that can be something that those kinds of things can be very important in the course of a trial.
So, Jim, a lot of this sounds like an argument for per diem damages. Talk a little bit about that. I mean, whether it's a money scale, what are sort of the pros and cons of approaching this from a per diem perspective?
Well, okay, from a pro standpoint, and I'm talking about from a plaintiff standpoint and why a plaintiff might like a per diem argument, there is this desire from jurors for guidance. They want some structure for how to formulate these intangible damages. But there is in my view, a very closely associated downside or danger with a per diem if it is not very, very simple. If there is too much focus on the calculation, too much focus on how we're getting to these numbers, and all we're now talking about are piling up dollars day after day, hour after hour, whatever your period is, and it starts to look like we're all in this for the money rather than rescuing this family, or rather than making a difference going forward, then a difference from something other than just getting rich, then a per diem can be very dangerous. I do think it has potential, but it's got to be used very carefully and I think very simply. That's my view of it.
I totally agree. And Jim, one thing I would add too is even when not given a formula, a lot of jurors create one.
Right.
So you are dead on, because you've got to keep it logical and simple. It can sound arrogant to get too fancy. I mean, I was just in Dallas yesterday in a mock trial, and the damages was obviously a big deal, and jurors who had to struggle to understand it threw up their hands. And now you've lost control over how the jurors are calculating it. So it has to be defensible, obviously, but also very logical. I will also say, you won't be surprised to hear this from me as a social scientist, that especially in this new world post-ruling, doing a mock trial is a very smart idea. Listen to where the jurors' minds are. Let them be your starting point in terms of determining not what the amount is. You shouldn't be thinking you're predicting verdicts with damages, but what their process is. What are the formulas they use? Do they like yours? Did they reject it? Did they come up with something else that it helps, whether plaintiff or defense, especially if defense is arguing alternative damages, that you can use them and their wisdom as the starting point rather than forcing something down their throats that they may reject.
And let me add in one more thing there that builds on this. The way I read Gregory versus Chohan, and it's not clear, but I think that what they are saying, the plurality is saying, we are not requiring a precise calculation. What we are requiring is some sort of rational connection between the intangible amount awarded and the evidence. And so they're basically, I think, saying we've got to see how it is that you are rationalizing this amount, not how you're calculating this amount, which again, I think points back to, we don't have to have our plaintiffs up there looking like accountants, doing a bunch of fancy calculations. We just have to have some sort of rational connection or rational suggestion for a way to look at the intangible damages.
One way that some of us talked among ourselves about the other day, that's an alternative way to do that, that I think has some intuitive appeal to it. And again, not to be you up there doing a bunch of numbers, but to give people an idea, is and it's used in public health a lot, in fact, when the government's evaluating whether or not to invest in some kind of research project or that sort of thing for health, they look at what is going to be the net benefit in terms of the additional years of quality life that are added. And they measure what's the value of a year of quality life. And the way they typically, one of the primary ways they do it is they look at, how much people pay in order to, if they are able to avoid a risk, how much they will pay to avoid that risk, that sort of thing, and what the probability is that would end their life sooner, and that sort of thing. And you can boil that down to something fairly simple. And then Karen pointed out the other day, and can speak to this better than I can, from a plaintiff's perspective, you then have, and they didn't ask to take this risk, because
Right.
which is a very different situation, which adds to it. And it's not a formula, but it plants that seed and it brings a quantitative element to it. But that's just one other potential approach to use in this context.
Well, and of course, one of the things that's nice about that is it helps you with challenges to experts, because I think we've seen a number of defendants filing motions to exclude, motions to, motions in limine on unsubstantiated anchors and things. And I want to get to anchors in a minute. But Karen, what were you going to say about that?
But just reflect on something you said, Jim. I think what we can agree on with jurors is that they're looking for what is reasonable. So it's about how you're framing the dollars as opposed to what the dollars are. And so I concur with you on that. And it gives opportunity for plaintiff and defense to try to win the reasonableness game. Because jurors will lose total faith sometimes in a liability case if they feel like plaintiff went too far, went up too high, and was not reasonable. Same is true for the defense. If the defense is pushing back against the plaintiff's ask and brings a level of dismissiveness or arrogance to it, then that can affect liability. And, I want to believe rational people go in order, but jury research has taught me that rational people often go backwards. And that means sometimes damages does drive some things in terms of liability judgments. It's not like jurors are thinking, wait, I can't think about damages yet. It's the last question on the verdict form. So it's all a confluence together. And of course, they'll have heard it all before they start to deliberate, unless your case is bifurcated.
Yeah, the thing that Dan Kahneman got his Nobel Prize for was basically a proof that we're not rational at all in the way we go about doing things.
We feel our
Fair
way
point.
to decisions and then justify them rationally. It's
Correct.
Exactly.
That's right. We start with the emotional and we go to the logical in our brains. And neuroscience has proven that.
Yes.
So, there's a lot.
Which is part of the reason why. I mean, one of our questions that we have from a viewer is, so how do you make that connection between damages to reputation or mental anguish? How do you make that connection? Well, some of it is having, I think, an emotionally compelling story that invests the jury in that story, and then giving them a framework that feels rational, because I mean, what's one of the accusations that defendants make all the time? They're just pulling that number out of thin air. There's no basis for it. There's no connection. And I think there was always a need to ground your numbers somewhere. Gregory just seems to suggest it's going to be scrutinized more carefully, the way in which you ground it, the way in which you suggest it's rational.
From a plaintiff standpoint, I think this actually both makes the plaintiff's attorney's job harder in the beginning, but if followed through on, makes the delivery of the case that much stronger. In other words, by having to think through not using unsubstantiated anchors, how am I going to substantiate this? And not necessarily in a dollar for dollar calculation, but in some sort of rational connection with how I'm getting to this number, it actually intensifies that plaintiff messaging. It makes it harder, but it makes it better.
But totally, because it helps convert a pro-defense juror when the plaintiff's attorney does that.
And it's
So
anchoring.
let's talk about
Yeah, the thing about anchoring that you're talking about here, again, without showing all the math and getting all the into the weeds, if you can explain to them, take your pick, either one. This is how we decide how much money to spend on making people's lives better through cancer research. This is an anchor. This is a way that people in the real world go about making this type of decision. Very smart people have studied what's the relationship between money and solving problems and that sort of thing, and your well-being and your happiness, and this is this is tied to the way people have done this in the past, the way people have demonstrated this, and again, it gives them something to hold on to that's not just the pulling the number out of the air sort of thing. I mean, it gives some sort of anchor, and then of course it's up to the defense to attack that anchor. I mean,
well, that's a huge part of the Gregory opinion, is this idea of unsubstantiated anchors versus anchors that are related. And so how would you look at what a substantiated anchor might look like? I mean, we've talked about the study and calculating well-being. What are some other ways to approach this dilemma of anchoring? Don't all jump in there at once.
Well, I think
softball, right? That's the easy part.
Well, I think these are pretty good. How do we value quality of life when we're deciding how much money to spend on medical research? How do people who study quality of life all the time intensely and look at hundreds of thousands of people figure out what the numbers should be? How do people who achieve improved lifestyle through mental health counseling and that sort of thing, how much does it cost to do that? And relative to the success? I mean, I think these will meet the criteria, as I understand it. Again, I'm not the lawyer, but and Jim would be better than I would to speak to this, or Liz, but to me, that meets the standard of there is a real anchor here. It's not 2 cents a mile for every mile a truck drove or something. I mean, it's a real anchor that's based in the human condition and the lives we all live every day. And I think that's in essence what they're asking for.
And that's why I'm always hungry to do research when I can, because you want to start with the multiplier or the formulaic anchor based on what jurors trust. And so that juror who says, counseling gets you nowhere. First of all, you want to identify, if you're the plaintiff, you want to identify and excuse that juror for obvious reasons. But let's say you've got a healthy percentage of jurors across the board in a given case who believe counseling gets you nowhere, then it means you've got to figure out what the other anchor is. Otherwise, you're wasting your breath talking about the great things that are going to come from it. So it again also has to bring in the fact that you first need to persuade jurors that this is more than a sad loss over the course of a natural progression in life. This is an extraordinary loss. So now you're in your liability case more so than you are in your damages case. And if you meet that threshold and exceed it, now you've got momentum to go into plaintiffs. But it's also, again, figuring out what are those kinds of things jurors would say, well, if they had only attached it to X. And I know you're asking what X is right now. So I'm telling you more of a non-answer in my process necessarily in trying to get to in jurors' heads about it. But it would be fairly simple to do that kind of research, but I think that's something that this is demanding even more since this opinion came down.
Let me ask you this.
Oh, go ahead.
The question that comes to mind as I'm sitting here thinking about that is, and this is maybe the inverse, Ray, of what you're talking about with valuation of happiness, is the valuation, the cost of the mental, emotional cost of trauma. Because certainly I've not had a reason to go do the specific research, but Karen, what you're saying makes me want to go do the research.
Yeah.
How has the impact of trauma on emotional lives, on future development, how has that been quantified? Is there research you're familiar with out there?
Yeah. There's a lot of research on the impact of mental health, trauma, that sort of thing on children and how it affects their educational performance and then hence their lifetime earnings and a lot of other and that sort of thing and then their emotional well-being and those sort of things, which is less quantifiable. But those types of studies have been done by social scientists for years and years. We've used them a lot in our work and trying to get funding for mental health and things like that.
I will add though that what we find is that gets you about, I'm making up this percentage, 70% of the way there in persuasion. The other 30% for getting fully there to getting a jury motivated is hope. If all they feel this is I got to give money because they were traumatized, you will not carry your full jury. And this has been true forever. Jurors are driven to despair pretty readily, but they ultimately need a reason to hope. And using themselves as intervention, part 3 of the story is now I, the juror, am the intervener here. And I have power to provide hope to these plaintiffs out of the despair that they are experiencing.
The way I often hear it voiced in focus groups is the question, how will this make a difference?
Exactly.
Exactly. And that is in many ways the antidote to the defendant's position of money doesn't buy happiness, money won't make this go better. And so you sort of bundle all that together. No, there is data that suggests it does, combined with, and this is the hope, this is the hand up, the don't make them pull their own bootstraps, give them a hand with that. But, these are all very plaintiff facing anchors and methodology. I know we, the Supreme Court, didn't like the 2 cents a mile, but are there defendant facing calculations? We have a viewer who said, well, what about in a premises liability case for failing to provide adequate security? Can the cost of the security guard be an anchor? And then, Jim, I know we've talked about in your world, why do we highly compensate CEOs and other corporate officers? Because it's such a stressful job. Let's talk a little bit about where defense numbers could become an anchor that could be used either way.
Well, first of all, they do definitely, just the fact of a defense number does change the dynamic in the deliberation room, for sure. Because if you have defense-leaning jurors, they're going to go there. And now that becomes the point of bargaining. Even when a jury instruction in a jurisdiction explicitly says, do not average, jurors average. Happens every time. So, they get to a conciliation on that. But I actually love that concept of the security guard because it feels relevant now to the case fact pattern. And I think that's a big part of what we're all talking about here is how do you make it feel apples to apples? How do you make it feel like if we're talking about some specific facts about a trucking accident or premises liability, how do we make it feel like it's companion instead of something that's just more almost silly because we're now using some out there kind of formula?
So Karen, for you, does that mean there's a difference between talking generically about the value of a Gulf Stream and talking specifically about this company's CEO's jet and what they use it for?
Yes, although even talking about the company's CEO's jet is only going to appeal to a subset of your jury. That anti-corporate juror, so if we're still talking from the perspective of a defendant right now, that anti-corporate juror who is pro-plaintiff might love that, but the more defense-leaning juror is going to be someone who's going to recoil against it. So it really means trying to figure out, instead of going for the angry juror, how do I go for the more rational juror? So I just flipped us to plaintiff, to figure out what can I say that makes them feel like I have a basis other than just, I'm going to make you mad by pointing out how much the CEO makes.
Jim, you've talked a lot about stress of being a CEO. What are your thoughts on, or a corporate officer or whatever? How else could you use defense facing numbers as anchors, although cognizant of what Karen has warned us about?
I have not done the research to know whether there are numbers to support this or not, but I'm thinking, what kind of people are in that have a choice based on education, experience? Because part of what we're talking about with plaintiffs are situations where they have been thrust into a lifelong or very long time period stress situation with no choice.
Correct.
So what about people that have a choice, could do something and make a good living without being in a high stress situation? How much more does it take to have them take on that high stress situation? For example, private security contractors in a war zone, because those can be highly compensated individuals. They bring lots of skills to the table that could translate into a good living, not necessarily at that level, but a good living elsewhere. How much more does it take for them to, in essence, be convinced to live their life that way in a continuing high stress situation, just for a year, 2 years, 3 years at a time, and then multiply that over a lifetime? I don't know what research there is to support those kind of numbers, but that's where my thinking is going.
And Jim, that's precisely how the health authorities go about deciding how much to invest in certain things. That's that when they try to look at the change in the what they call qualities, QALYs. It's a year of quality life is what it amounts to. That's how they measure that. You increase the probability of losing your life or having an injury or something like that, and how much compensation did you require for that? That gives them an idea of the value of a human life, which they can in turn translate into, okay, this particular drug will save this many quality years of life. What's that worth? How much does the research and the implementation cost to get it there? I mean, it is very well anchored in public policy. Exactly.
And to me, that is not a precise calculation of what the stress cost in this case, but it's a rational basis for it. Mm-hmm. It's not an unsubstantiated anchor.
That's right.
But I would put some warning label on it, because you want to make it as close to home for jurors as possible. Agreed. So if you're talking about somebody in security in a war zone, you now need to make sure jurors see this as the experience of the plaintiffs as war zone-esque. So if you can get them there, brilliant. That's a great way to do the calculation. The question is, will jurors accept that analogy or not?
Or is it an overreach?
Is it an overreach? Right. Does it feel like, yep, I've been through that and I totally can see that as a war zone kind of feeling? For example, PTSD. Now, we know that post-traumatic stress disorder is something that has been studied deeply with the military, for example. That could be a bridge, because if you've got an expert as a plaintiff's expert who takes the stand and says, absolutely, this is post-traumatic stress disorder, similar to military. You have now planted an anchor of a noun, military post-traumatic stress disorder. That could be an example of a connector or a bridge to then make the point that you're making, Jim.
Because there are other kinds of security that didn't require you to be in a war zone, but we talked about this earlier. The security of a child going to bed knowing both their parents are home, right? The security of, I mean, how many of us with teens or older sat up waiting when they were out newly driving out on the town, et cetera. And so I think there are familiar security analogies that really could come into play here that would feel familiar to the jurors.
The other thing, listening to that, Liz, that I would add is this is why it's always a sound idea to listen closely to jurors' own examples during jury selection, and then to figure out, how do I make those experiences quotable? For example, we have often worked on cases where we had a great gem come from something a juror said and put that quotable into the opening. You could do something similar in what we're discussing right here. And I'm not suggesting you totally change your analogy and theory based on one quote, but to listen closely to the examples they give, and then for your expert to pull some of that in, use it as for example. And that is a micro celebrity moment for jurors, but it also shows you're listening and that you've been given data in the jury selection for the actual case that you are weaving through your case. And either plaintiff or defense should be thinking about that.
Yeah, because you'll hear things that, again, it's almost like last minute jury testing, because you've already had somebody who's actually going to be on your panel
Exactly.
introduce this as a validating concept, which is really important. We have a question from one of our viewers that said, so we've got a permanent disfiguration case. We've got burns, which are permanently disfiguring, even if we have skin grafting and all of that. Is per diem a good argument in that kind of case? I mean, while the Gregory case was specific to mental anguish, I don't think most of us feel like it's going to be limited to that one particular kind of non-economic damages. Is per diem a good option in something like that, where it is something they'll face every day?
I haven't thought about it, but Ray, if you have a thought.
I was just thinking that's kind of Jim's area. I was going to defer to him, but I mean, there are circumstances. There are circumstances where it's appropriate. Yeah,
and I'll give you my thought. If it is something that the evidence shows they feel like they're being shunned because of it. It kind of depends on what the disfigurement is, how apparent. But if they feel like on a literally everyday basis they're being shunned, yes, possibly. But I still have the same concerns that I expressed before, and maybe even more so. For a per diem to justify getting into the kinds of calculations, number one, keep it simple, and number two, to even justify getting into it, I think it's got to be significant. And so if it rises to that level of significance, and certainly some kinds of disfigurement absolutely can, then yes, I think it could work.
Mm-hmm.
I agree. And it's right along with the lines of what you said, Jim, but I would add another nuance on top of it. And that is, again, think about the hope angle. So the cost of being shunned, absolutely valid. But if you can frame it as courage with a cost, now you're going to hope. The courage it takes to literally show your face in public every day, and the cost of that courage. Now you're shining the light on a resilient, courageous plaintiff. And that can be more motivating to a juror than the cost of being shunned. And of course, it requires a strong psychology expert who can speak to that. But I totally think per diem could work in that regard.
And it's an interesting thing because we tend to think of per diem as static. There is a per day cost that is the same. I think it opens up kind of an interesting possibility that, we get accustomed to how we look, right? We look at ourselves every day. And so there's sort of a desensitizing to it. Yeah, it was horrible when you first there, and it's not how you looked, but you change. But every time you meet somebody new, every time you're thrust into a new circumstance, I would argue that it's per diem for you with spikes every time you're thrust into. I mean, imagine if this was a a child or a teenager, when you go to high school, when you leave for college, if you go to grad school, when you start a new job, you get these spikes. And so maybe per diem needs not to be merely this flattened idea, but that it's got peaks and valleys.
That's interesting.
Yeah. Ray, I think you were going to say something too.
Well, I know we're running toward the end of time. And one thing that came up with something Karen just said just now is about a psychology expert. I think one thing that this decision does is suggest you're probably going to see, kind of like in other branches of litigation now, you're probably going to see more teams of experts than you've seen before. You're going to need a psychologist or someone who can speak to and make those critical points that Karen and Jim were just talking about, and then let the more technical expert weigh in and rely on there'll be an economist, accountant, or whoever that's going to do the calculations, weigh in on that. I do think you're going to see this probably evolve into a more of a team of experts type of approach, like you have in patent cases where you have technical people and economic people, or in personal injury cases where you have the life plan doctors and then you have somebody doing the numbers. You're going to see this type of litigation evolve into that in a much more significant way, I think.
And you're right, we have but minutes left, so I want to go through the group and get final thoughts. Karen?
Oh my. Well,
I can make it be Jim.
This is a smart panel. Can I say that? Also, that I think a big part of this is I'm listening to the things that you're contributing to is trying to figure out how to motivate, if you're the plaintiff, through the damages award, and determining, is it reward or is it punishment? Now, punishment is if you have an arrogant defendant. And of course, you're not going to use that word. You're not going to cross over the line of treating it like punitive damages, but there is power in knowing that jurors might. So the reward part is what I've been saying in terms of give jurors reason for hope. And so back to the per diem we were talking about with the disfigured plaintiff, reward is for having the courage to go out in the world versus despair, which is poor woman. And so when you can treat these like reward, build that into the formula in terms of how you figure out what that per diem is, but know that that is the motivational kicker or additive to what you might normally seek.
Ray?
Well, first of all, I'd just like to say it's a pleasure to be with all these folks. This is I hope this was very informative to everyone. It's certainly, I learned some things today. And no, I would just say that again, I think it's critical that you have the story that you tell and be a compelling story. And now that story is going to have some degree of anchoring in some type of quantitative measure without making it too complicated. All that's been said, but I think that's the real key, is to make sure that the person providing the numbers can effectively tell that story. On whichever side you're on, tell that story with a good solid anchor for it to give the jury something to work with. And I think something I've experienced many, many times that Karen emphasizes from her work is always make it about hope.
Jim?
Yeah, Liz, I'll come back to the very basis for why we wanted this particular panel here today. I think this has been a very illuminating conversation, and it points to something that I think in a catastrophic injury case is imperative. I think that a good lawyer needs to start with a pair just like this, where you're getting that research-based logical input, rational input about the rational basis, and that very rich understanding of where jurors are coming from. Going back to what Ray was saying about the story, and being sure that that rational basis is being presented with the right story anchors. And so this is exactly the kind of pair that I would start with. Somebody like an economist or other expert that has that rational grounding in research, and then that research-based understanding of jurors, a trial consultant. I couldn't imagine a better pair than what we've got right here.
Ditto. And I think my closing thoughts would be, this is definitely something that if you're handling catastrophic injury cases, you want to be reading some of this because, yeah, it's great to have a Ray Perryman who can tell you about the data. But I think if you're really going to be handling these cases, you need to know the limits of the data too, because you're the one that's going to be handling the Dalbert challenge or whatever. And so you've got to have some grounding in it. And then I think you need to be testing these. This is so important for jury testing, both concept focus group early on, just hearing
Yes.
the approach. And then as you get further down the road, you have your discovery largely done, those structured focus groups, so that you are not selling something the jury's just not going to buy. You really want something that intuitively and naturally will appeal to the jurors. So, my goodness, thank you to both of you. This has just been fascinating, and you are so tremendous at what you do. We're grateful for all of your support of Baylor Law. Hope you'll join us in January when our roundtable will be addressing artificial intelligence and what it means for you as attorneys from an ethics perspective. Talk about some surprising bombshells. Join us then and have a great day.
Thank you.